This is Otto the Watchdog.
Well, I want to hold my signs, and I'm on a very limited schedule. I don't have a whole lot of time left. So if I'm going to do what I'm doing to get my message out, then I need you to allow me to do so without doing violence to me. I'm going to continue to do it.
Well, right now you're still detained for investigation.
Okay. How long does the investigation take usually? Can I hold this sign?
My supervisor told me to hang on a couple seconds.
Okay, well, a couple seconds. You mind if I do this while... Can I do this? Hey, look, you haven't said no, okay? So that's why I'm going to continue doing exactly what I was doing. Okay, I'm not under arrest yet, so as long as you're okay with that.
As long as you're not doing the profane sign.
I mean, that one a little bit. This one is a little bit. This one's a little bit, right? You like that? It's funny, objectively funny.
Yeah, and that's
Is this one okay?
what we can get called.
This one? Or the other one? This one?
Both of them.
Both of them.
The ones that have profane.
Which one do you like better? Hey, so let's ask the trooper if he likes it.
Now we're gonna put the signs down.
Why?
Put the signs down.
There's a trooper. I want to show the trooper.
Put the signs down.
He's a police accountability activist and YouTuber who keeps getting arrested across Texas. He holds signs like these on public sidewalks, and he keeps getting handcuffed and charged with disorderly conduct.
If you keep cussing in public, you will be under arrest for disorderly
Cussing in
conduct.
public. Can I have a list of words I'm not allowed to say?
You're an adult, you know exactly what not to say.
Am I though?
Yes, you are.
How about this? Can I hold this sign?
No, that's profane. If somebody's offended, you're about to go to jail.
Why?
I'm trying to help
For
you.
what?
He witnessed.
Uh-huh.
Person.
I don't want to go to jail.
Then comply. That's all you gotta do. I'm sure that I can find somebody who was offended by your language.
That's great.
Someone's already called.
There you go.
Yeah. Is
There
that
you
all
go.
it takes
And
to
you
go to
said
jail
it
in this
in front of
country?
us.
Is that the only thing that takes to go to jail?
That's it.
You're making a mistake, sir.
No, I'm not. I've done
Well,
this.
you could call somebody, like the district attorney.
I don't need to call nobody. You're out here cussing in public.
well.
You gotta complain.
Arrested. Over and over again, different cities, same charge. Here's what these police departments don't know. I already won this exact case in federal court. I'm Brandon Grable, a civil rights attorney practicing here in Texas, and this is my channel, Clearly Established. I represented Brandon White in a case where he was arrested for holding a sign that said, "Fuck corruption." And a federal judge ruled that the officers who arrested him violated clearly established constitutional law and lost their qualified immunity. Today, I'm going to show you why every single one of Otto's arrests is likely unconstitutional. Let me show you why the case that proves Otto's arrests are unlawful. This is Brandon White. He stood on a public sidewalk in Corrigan, Texas, holding these signs.
Are you really okay with your mayor and police chief sleeping with each other? Fuck corruption.
Someone called the police, allegedly. Officers arrived, saw the profanity, and arrested him for disorderly conduct. Brandon sued in federal court, and here's what happened. The Eastern District of Texas issued this ruling. The court found that Brandon's speech was unquestionably protected under the First Amendment. Even though the sign contained profanity and criticized government officials, the police chief and mayor, it was political speech protected by the Constitution. The court said that the officer's argument that the sign was offensive offends the constitutional right of free expression. More importantly, and this is the part that matters for Otto and every person who chooses to hold signs or speak freely, the court held that the officers were not entitled to qualified immunity. Let me explain what that means, because this is critical. Qualified immunity is a legal doctrine that protects officers from being sued personally for their actions while on duty. But it's not an absolute protection. To get qualified immunity, an officer must show that either no constitutional right was violated or that the right wasn't clearly established at the time. In Brandon's case, the court said both prongs failed. First, there was a constitutional violation. The arrest was without probable cause because Brandon's speech was protected by the First Amendment. Second, and this is key, the right had been clearly established since 1971. Put down in the comment if you know what case I'm about to bring up. The court wrote that it is beyond debate that the officers cannot arrest someone for holding a profane protest sign absent some other conduct that actually threatens violence. That's the key part. There needs to be an actual threat for violence. The court rejected every argument that the officers made. The officers tried to claim that someone called and they were offended by the signs. The court said it didn't matter. They said the sign referenced specific people. The court again said it didn't matter. Under Supreme Court precedent, the Constitution protects offensive speech criticizing government officials. So what does this mean practically? It means Brandon's case can proceed. The officers can be sued personally, and if Brandon wins, they could have to pay damages out of their own pockets, not just the city. But of course, what ended up happening? The city and the officers settled. But it also means that every officer who arrested Otto made the exact same constitutional violation that this federal court already ruled on in Brandon's case. Now let's talk about Otto. Otto has been arrested multiple times across Texas, different cities, different officers, but the exact same fact pattern as Brandon's case. In each case, he held a sign, officers show up claiming that someone was offended, and he either gets arrested or ticketed, and in some instances prosecuted. Prosecution for holding a sign with words? Every single arrest follows the same pattern. Someone calls police, allegedly, saying that they're offended by a sign. Officers arrive, they see profane language, and then officers arrest or ticket for disorderly conduct. There's no violence or threat of violence, just hurt feelings. And a police officer who either doesn't know the law or chooses to ignore it. And here's the problem. Many of these cases eventually get dismissed. Does Otto sue? I have no idea. Should he? Probably.
That's our SWAT pin.
Your SWAT pin, your SWAT? That's probably a good thing. You handle a gun better than you did a law book, didn't you? Yeah. So I'm gonna. Do you want to get married for the next 3 to 5 years?
What's the relevancy?
Well, so if you continue doing what you're doing, we will be married for the next 3 to 5 years, and you will remember my name every single day.
I don't particularly want to marry you, sir, so.
Okay, well then you should probably turn around and get the fuck out of here.
Lawsuits help because officers in the neighboring towns or nearby towns will learn pretty quickly not to engage in this kind of conduct. I guarantee you the city of Corrigan learned in Brandon White's case. A lot of times, though, officers don't see the federal court order or see the legal analysis. They do understand, however, that people were sued, that settlements were likely paid, and some mistakes were made. It's obviously up to the city to make sure that officers are trained correctly. And thanks to social media, Otto's case, for example, and his circumstances shouldn't go unnoticed. We know police officers are watching auditor videos, and they should be watching Otto's videos, and they should understand the mistakes being made. So let me explain the law that's been settled for 50 years that this court in Brandon White's case relied on so heavily. And if you guessed the case was Cohen v. California, decided in 1971, obviously you're correct. In that case, Paul Cohen walked into the Los Angeles County Courthouse wearing a jacket that said "fuck the draft" in protest of the Vietnam War. There were women and children in that courthouse. He was arrested and convicted for disturbing the peace. The Supreme Court reversed his conviction. Here's what Justice Harlan wrote for the court.
The ability of government, consonant with the Constitution, to shut off discourse solely to protect others from hearing it is, in other words, dependent upon a showing that substantial privacy interests are being invaded in an essentially intolerable manner. Any broader view of this authority would effectively empower a majority to silence dissidents simply as a matter of personal predilections.
The court also said something even more practical, and this is what I want officers to remember. Those in the Los Angeles courthouse
Ooh, so now you're taking my job? Okay, carry on then.
could effectively avoid further bombardment of their sensibilities simply by averting their eyes. In other words, if you're offended by someone's sign, look away. The government cannot censor speech just because it's offensive. That was in 1971. The law has been clearly established for over 50 years. This is the precedent that the judge in Brandon White's case cited to in 2025. And this is the same precedent that makes every single one of Otto's arrests based on holding a sign unconstitutional. Now let's look at the Texas disorderly conduct statute and see what the law actually requires, because this is what officers are getting wrong.
A person commits an offence if he intentionally or knowingly makes an offensive gesture or display in a public place and notice I didn't say or I said and the gesture or display tends to incite an immediate breach of peace.
There are three critical elements here that the officers need to understand. First, offensive gesture or display. Sure, I would say that Otto's signs could qualify as a profane sign, that this would meet element 1. But that's not enough standing alone. Second, the sign tends to incite. The sign has to be the type that would cause an average person to want to fight, not just feel offended, not just uncomfortable, actually want to fight. Third, immediate breach of peace.
Come on. Well, now you're gonna get it, motherfucker. That's right. You and me. Right now. We're having it out. Let's go. Come on. Come on.
Texas courts have held this means actual or threatened violence. Let me show you an example from Texas case law. In Cohen v. State, the Texas Court of Appeals analyzed what constitutes fighting words. The defendant gave someone the middle finger from his car as he drove past them. The court held that this was not disorderly conduct because the encounter was too brief and impersonal. The complainant was momentarily angry, but there was no actual violence or threat of violence. So ask yourself, if flipping someone off while driving by isn't disorderly conduct, how could holding a protest sign on a sidewalk be disorderly conduct? The answer is, it can't. And that's exactly what the federal court said in Brandon's case. Brandon's sign said, "Fuck corruption." Otto's sign says, "Fuck bad cops." Someone being offended is not probable cause. Someone calling 911 because they don't like the message is not a breach of peace. The statute requires actual violence or the immediate threat of violence, not hurt feelings. I'm going to do something a little different here. If you intend to engage in similar conduct as Brandon White or Otto, I encourage you to clip this portion of the video and have it ready for any officers that intend to approach you.
This won't work. Everyone here thinks cops are idiots.
If you're an officer watching this video, and I hope you are, especially if you're in Texas, because I am a Texas civil rights attorney, I need you to understand something very clearly. I'm making this video because I would rather educate you than sue you. I would rather you understand the law than violate someone's constitutional rights. Because the next time Otto, or someone like Otto, or this individual holding a sign, you're going to have to make a decision. Here's a federal judge in Texas who is telling you that arresting someone for holding a sign violates clearly established rights. Now, here's what you need to understand about the decision you're about to make when someone calls to complain about a sign. You're not just deciding whether to make an arrest. You're making a decision that could affect your personal finances for the next decade. Let me show you why. This is Texas Municipal League's liability coverage document. This is the actual insurance policy that most Texas cities, probably including your city, uses to cover lawsuits against officers. The city's insurance doesn't have to cover you. So the city's insurance may not pay for any judgment against you or pay your lawyer to defend you either. But this is what I mean when I say you're making a decision about your personal finances. The federal courts have ruled already, time and time again, that there is nothing wrong, nothing disorderly about holding signs. So now you cannot claim you didn't know the law was clearly established. That defense is gone. So before you make that arrest or issue a citation, here's what I recommend. First, ask yourself, is there actual violence or threat of violence? If not, there's not an offense. If someone's upset by a sign, that's not violence. If someone calling 911 because they don't like a message, that's not a breach of peace. Second, call your supervisor. Call your city attorney. Let them make the call if you're unsure. When you call, here's what I want you to say. I have someone holding a sign that says "fuck bad cops." Someone called to complain. Is there probable cause for disorderly conduct? given the Cohen v. California and the recent Brandon White case in the Eastern District? Any competent city attorney would tell you no. Third, I want you to document why you chose not to arrest in your report. Complainant reported offensive sign, observed First Amendment protected speech, no breach of peace, no violence or threat of arrest, no arrests made per Cohen v. California. Done. You're covered. Because here's the thing. I've deposed officers in cases like this, and the most uncomfortable moment in these depositions is when I ask, "Officer, were you aware of Cohen v. California before you made that arrest? Knowing what you know now, would you have made that same arrest?" And can you imagine when they have to answer no while sitting across from their personal attorney? Hopefully one they didn't have to pay out of pocket for because the city's insurance wouldn't cover it. Look, I don't want that for you. So please, save this video, share it with your department, show it in briefing, show it to your supervisors, show it to your city attorney. And if you're on a stop right now, let that person go. They're doing nothing wrong. Look, these people aren't trying to ambush officers with a lawsuit, as far as I know. But I'll tell you what, after the Brandon White case, after the videos I'm seeing of Otto, after 50 years of clearly established law, officers can't claim they don't know. And if you're thinking that your city's insurance policy might be different, it could be. Maybe it isn't. I'd encourage you to ask your city attorney, read the exclusions for yourself. Look specifically for exclusions related to constitutional violations or civil rights violations. And if your city attorney hesitates to give it to you, that should tell you something. All right, so back to everyone else. What does this mean practically? For activists and cop watchers like Otto, you have a clearly established First Amendment right to hold profane signs criticizing police or public officials on public property. Period. Even if someone finds it offensive, even if kids see it, even if someone calls 911. For police officers, understand that being offended does not equal probable cause. Before you arrest someone for a sign, ask yourself, is there actual violence or immediate threat of violence? If not, you're violating clearly established law and you can be, and most likely will be, sued personally. For police departments, train your officers on First Amendment law. The fact that Otto has to keep getting arrested in different cities isn't just bad apples. It's a training failure across multiple agencies, and frankly, it's pretty frustrating. The Brandon White case, for example, gives you clear guidance. Use it. And for prosecutors, stop filing charges on these cases. You're wasting taxpayer money prosecuting violations of settled constitutional law, and you're exposing your officers to personal liability when you know they'll lose qualified immunity for pursuing it. So here's what you all need to remember. Cohen v. California was established over 50 years ago, and it says that profanity on signs is protected speech. The Texas disorderly conduct requires fighting words that cause an immediate breach of peace. There must be actual or threatened violence. And then Brandon White's case in the Eastern District of Texas, where the opinion was issued earlier this year, confirms that officers lose their qualified immunity for these types of arrests. And city insurance policies may not cover officers for constitutional violations. Every arrest that I have seen so far, like Otto's, creates potential personal liability for the arresting officer. This isn't a gray area. This isn't officers making judgment calls in ambiguous situations. This is clearly established constitutional law that officers are ignoring or were never properly trained on. It needs to change. And now that Otto's story is getting more exposure, ignorance is no longer and should have never been an excuse. The First Amendment exists precisely to protect speech that people find offensive, especially speech criticizing the government. As the Supreme Court said, we distinguish a free nation from a police state by whether individuals can verbally oppose or challenge police action without risking arrest. Otto the Watchdog has been arrested over and over for exercising that very right, but the case law is clear that when officers make those arrests, they're unconstitutional. So whether you're watching this as an activist, citizen, cop, know your rights, document everything, and understand that this type of protest has been protected by well over 50 years of clearly established law. And if you're someone who's been arrested for holding a sign, whether you're Otto or Brandon or anyone else, you may have a valid federal civil rights claim, and the law is on your side, at least in Texas. And I'd rather make 1,000 of these educational videos than file a single lawsuit. But if officers continue to make these arrests after videos like this exist, after Cohen exists, after the Brandon White case exists, after 50 years of case law exists, then some lawyer, maybe me, maybe someone like me, will be asking those officers questions under oath about why they thought they could arrest someone for speech that's been protected for dozens of years. This is clearly established, and thank you for watching.